May it please the court. Dinah Stein on behalf of Dr. SARANITA. I understand Your Honor's already reserved rebuttal time.
Actually, counsel, if you'll just wait just a second, I'm going to call it on the record. I forgot to do that part, which is my job that I forgot to do. All right, so this is SARANITA versus PAGAN, 18-2216.
Thank you, Your Honor. The order granting a new trial that we're appealing was based on a single comment. The single comment disclosed information that the jury had heard from 3 different witnesses already, including 2 of plaintiff's experts and the defendant, Dr. SARANITA.
Do you agree the objection, so the issue is preserved, it's not necessarily a fundamental error discussion today?
There's no fundamental error discussion today because there was only one comment that was preserved, which is what the trial court based the new trial order on. He never found fundamental error on anything else.
I know there's some discussions about whether that type of comment may be fundamental error in other cases, but actually for us today, in other case law that was cited, and actually for us today, though, the issue, if I understand it, correct me if I'm wrong, is the granting of the new trial, was that an abuse of discretion based upon the court deeming that he shouldn't have overruled the objection and it was error because it was improper bolstering and therefore a new trial is required?
That's correct.
That's exactly what we're here about today, and that and only that.
It's exactly what we're here about today. However, given our arguments, the fundamental error argument falls aside anyway, because of our arguments that this was, the testimony, and just to get right to the facts, was that the FDA considers 60 milligrams of MS Contin to be a safe dosage. First of all, Dr. Bird, the plaintiff's toxicologist expert, testified the FDA considers 60 milligrams at 7 days to bring a patient to tolerance level, to respiratory tolerance level.
Is there a difference between that testimony that was focusing on opioid naivete or opioid tolerance and the statement that this is a safe dose?
Absolutely not. And in fact, Your Honor, because that's a very important point, plaintiff's counsel elicited the same testimony about the tolerance from Dr. SARANITA in his cross. In redirect, the defense lawyer actually tied that in. He said, and there was no objection to this, he said to Dr. SARANITA, you were asked about this, the 7-day tolerance level. Yes, I was, and that's what the FDA says, yes it is. Well, wouldn't that mean that it's a safe dosage? Yes, that means the FDA is a safe dosage. So this came out from Dr. SARANITA in her redirect, and there was no objection to this. And in fact, and it's what we said in the briefs, I think it's obvious that if the FDA is saying, which everybody heard, that a patient can be started on 60 milligrams for 7 days, they're not going to allow this to be a fatal dose. Now, just to also tie that into, and I think this is also important, the plaintiff's theory of the case, because plaintiff tries to make it sound like this was the be-all and end-all of the testimony, whether 60 milligrams is this dangerous dosage. That was not plaintiff's theory of the case. The plaintiff's theory was that you don't give long-acting opioids, MS Contin, to a patient like Mr. Pagan, who has sleep apnea and is obese and is naive. That was their theory, is that you start them on this short-acting and titrate it. In other words, you go from 30 milligrams to 45, so you can see any side effects, and you just don't put them on a long-acting. The plaintiff wanted the jury to hear about the FDA standard because his theory, and this is from his own closing argument where he got up and he said, everybody knows the FDA standard. What he was trying to show is that the FDA created this baseline for healthy patients. The FDA, there was testimony that the FDA doesn't even test patients who have sleep apnea because they consider it too dangerous. So what plaintiff wanted the jury to hear is that was the baseline. Mr. Pagan was not at baseline, and so that was the negligent act in giving him this drug, this particular patient, at the 60 milligram dosage. So this thought that this was some bombshell testimony wasn't. It wasn't. And the fact of the matter is, plaintiff elicited it purposely from his own experts and from Dr. SARANITA repeatedly. I mean, this is what he wanted before the jury. So it's, and that makes it, because he wanted it in there and because there was absolutely no objection when Dr. SARANITA actually tied it in and said, it's safe. This falls into the cases we've cited, Detroit Marine, Eichholz, Metropolitan versus Coates, Metropolitan-Dade versus Coates, where if something comes out, some information that the jury hears comes out, regardless of whether it's proper or improper, it's going to be deemed cumulative and harmless if the jury's already heard the information without objection. And that's exactly what happened here. Now, just to go one step further, because this was clearly just not something that even conceivably hurt the plaintiff when it came in multiple times. The other is what the trial court seemed to focus on in the new trial order, and this is a lot of the focus of plaintiff's brief, was defense counsel's what he perceived as a stipulation during the testimony of Dr. Rauch, the one who said the statements, that it was improper because there had been an objection, it was overruled, that was the one preserved statement, it came out, that when plaintiff's counsel actually approached the bench and Mr. Womble, the defense lawyer, agreed to instruct the witness not to bolster his testimony, first of all, I think he was taking an overly cautious approach. He didn't want any perception of bolstering. But at that point, Dr. Rauch started to testify as to whether the decedent had been opium tolerant or naive from the time the last prescription was made until his death. That was a specific question. He started to then get into the FDA standard for that. And that's when Mr. Womble, the defense lawyer, said, I agree, let's just stay away from that. Let's just go on your own experience. And so he did take an overly cautious approach, but note that after the time of that objection when the witness was instructed, he again twice referred to the FDA standard without any objection or motion for mistrial. So I think it was understood that it was a very limited agreement of what he wouldn't bolster his testimony with. The other point of that is for plaintiff now to come in and say that this was harmful, I think is baseless given plaintiff's own very emphatic argument before trial that FDA comes in. I mean, the plaintiff he was asking the court to take judicial notice of FDA standards. He wanted to bring in the product insert on the grounds that the FDA approves it and said this is government, it's FDA, it comes in. That was never ruled on, and that issue kind of died on the vine. But the plaintiff took the position all along that FDA comes in. And in fact, there was agreement that the FDA has this standard. Everyone knew it was a 60 milligram standard. That's frankly an exception to the hearsay rule. I mean, the FDA is the government. It's a government report. There's a Benjamin versus Tandem case that says where the FDA has an advisory, that's an exception to the hearsay rule. So there's nothing improper inherently about this FDA standard, but even if there's not, but if there was, everybody agreed, and plaintiff's counsel himself stated in closing that it's an industry, it's a standard. Plaintiff's own words, and just since I'm referencing it, it was page 2795 where he said everybody knows the FDA considers this 60 milligram standard as the baseline, and you gave somebody who had sleep apnea the wrong drug for him. So again, this was something plaintiff owned. They wanted it in there, and for them to turn around and say this is a basis for a new trial, which a court apparently agreed with, is just completely unfair. Now, just to be clear, and I won't spend a lot of time with this, but it was raised in the briefs, there was no other basis, tipsy coachman, for a new trial order. And the court made that clear. He went through the other grounds that had been raised. There were many points raised in the post-trial motions. He rejected them all. The business with the product insert, and I'll just, to bring that back to this FDA issue, the court never definitively ruled on whether the product insert would come into evidence, but the plaintiff makes a point that a juror asked about the FDA standard through the product insert. That's actually not accurate. The jury heard about a product insert. They were told specifically by Dr. Landers, the FDA doesn't draft these product inserts. They don't do that. So they didn't know that it was an FDA standard. They didn't know anything about the product insert. One juror said, is the product insert going to come into evidence? That has nothing to do with anything. The product insert issue was never ruled on before trial, and plaintiff never re-raised it at trial. Plaintiff had raised an issue about a violation of the rule of sequestration. The court actually gave a pretty draconian, I think, penalty to the defense for that, well within the court's discretion for doing that. The court found that there was no issue with the defense eliciting testimony about the decedent's noncompliance with his opioids. And in fact, he noted that the plaintiff relied on that evidence to show that he wasn't always taking his opioids and therefore was naive. And lastly, the plaintiff had raised an argument about an improper comment in the motion for a new trial. That was based on the evidence. And the plaintiff, I think, has made pretty conclusory responses in the answer brief as to those other 4 points without really putting in any evidence as to why those would have been alternative grounds for a new trial. But we just want to point out that there were no other grounds for a new trial. This was actually a very clean trial. It is fundamentally unfair for Dr. SARANITA to have to redo this based on a comment that was absolutely cumulative, harmless, and came in through three other witnesses. So we would ask that the court reverse the order granting.
So, let me just.
Yes, Your Honor.
So it's within the trial court's discretion to impose a draconian sanction? Those.
Well, so the rule of sequestration, the plaintiff wanted the trial court to strike the witness entirely. And what had happened, it was just that it was inadvertent. I mean, there was a lot of questioning as to the defense lawyer, as to him telling an expert about some new testimony, and it was admitted to. It was, they owned up to it, and it wasn't intentional. And so the court determined he wouldn't strike Dr. Rauch entirely, but he instructed the jury that the rule had been violated, essentially. He said he was told something he wasn't supposed to be told. Not only that, Dr. Rauch was not allowed to then testify about this new testimony, which was the widow had testified for the first time at trial that she put a drug in a Dixie cup.
Do we afford a trial court more discretion in the granting of a new trial as opposed to the denial of a new trial?
Yes. I mean, that's basic laws, that the court has very broad discretion in the granting of a new trial. We don't have any issue with that standard in making these arguments today, but there still has to be a showing on the record when they grant a new trial as to why a new trial is necessary. There's no showing on this record or in the court's order granting a new trial as to why. It appears that the court's main reason is defense counsel's agreeing to instruct his witness not to bolster, and that's it, as if that was a confession of error, without addressing the harmfulness or the fact that it had already came in 3 times at all. So, we go to just the harmful error test. If there's no reason, we have to show there's no reasonable possibility that the jury was impacted by.
Well, I mean, but the trial judge explained his reasoning why he granted the motion for a new trial, and we have the abuse of discretion, but it's even a higher deferential abuse of discretion standard because it was granted the new trial as opposed to. So the question is whether that judge's reasoning based upon the record constitutes an abuse of his broad discretion after looking at what went on at the trial to grant the new trial. We have to then conclude that he did abuse his broad discretion for you to get the relief that you're asking, right?
That's correct. And we know that it's broad, but it's not unbridled. And there are numerous decisions out there, many cited in our brief, where a new trial order has been reversed because the judge abused his broad discretion. I think it's a pretty simple issue here. We have one comment that was preserved, no other motions for mistrial, no finding of fundamental error by the judge. He didn't even address it. He just focused on the one comment. We have 3 other witnesses who said the same thing. And plaintiff's counsel, all elicited by plaintiff's counsel, and discussed in closing. This was evidence the plaintiff wanted before the court. So the discretion's broad. It's not unbridled. This is a very clear record and a case for reversing the order granting a new trial. So unless your honors have additional questions, I'll save the rest for rebuttal. Thank you.
Good morning. May it please the court, my name is Chris Carlisle. I'm here on behalf of the appellee. Your honors, at trial, the trial court and opposing counsel both recognize that the defense expert witness improperly bolstered his testimony. There's no doubt about that. It happened. Now we hear that it wasn't a big deal, that all the case law that we say that this type of situation deprives the parties of a fair trial, the case law that says it rises to the level of fundamental error, you're being asked not to pay attention to that. That doesn't matter. You're also being asked to suggest, as Judge Lambert just mentioned over and over, that this trial judge, having sat through this trial, having focused on this key issue, having seen what the effect it had, having gotten a question from the jurors, not on this exact issue, but something dealing with the FDA, abused his discretion when he recognized, I screwed up. I should have not sustained that objection.
Should not have overruled.
Excuse me, I should have sustained the objection. I let this stuff in. And then to suggest there was one comment after the court overrules it. Is the lawyer going to draw attention to this? Yes, there were some additional comments that were not objected to, which again, the fundamental error issue comes into this. But are we going to say that no trial judge in the state of Florida, given that under these circumstances, and given what happened here, and given the high standard and how important in a battle of the experts, expert testimony is, and when it's bolstered, courts have found that it's fundamental, you can't do that without any objection whatsoever, that somehow you're going to say that that judge abused his broad discretion in that context? I think that is a bit of a reach. We've heard that this was really not a big deal, and I'm going to talk about a little bit how 3 witnesses talked about this. Judge Taylor, you were exactly right to raise the question that these references to the FDA, which were made in various contexts, references to 60 milligrams a day for a week being opioid tolerant, those are all different issues than really the issue that this case presented. What issue did this case present? Well, let's go back to the opening statement on the first page of the transcript of the opening statement from defense counsel. This is what he says at page 458. This case is about whether, on May 21st, 2012, it was appropriate to give the prescription for morphine that Dr. SARANITA gave to Mr. Pagan. That's what it's about. So be careful about collateral issues that don't really deal with what was appropriate. That's what they tell the jury right off the bat. This case is about that prescription. This case is about that. What does he say at transcript at 470, defense counsel to the jury? The testimony from Dr. SARANITA and Dr. Rauch were that the dosages were safe for morphine-naive patients and that they did not cause respiratory depression. Plaintiff's experts are going to disagree, but that is what our experts will say. This is the issue. And when you have an expert bolstering, clearly improperly, his testimony on the key issue of the case, you cannot suggest that the trial court abused its discretion in doing what it did. Now, again, going back to this, what are we talking about? We're talking about not whether or not 60 milligrams for a week makes one opioid tolerant. That's not the issue. That's a smokescreen here that everybody did agree to. The question is, how do you get there? How do you get to the 60 milligrams a day? Dr. Bird testified, and the testimony throughout this trial was low and slow, that the dosages need to be brought on very slowly. And the question about whether he was opioid tolerant or naive at that point, the experts disagreed. But the point is, the expert testimony from the plaintiff's side was that this was inappropriate, that it was too fast. Not that 60 milligrams for a week is going to make you opioid tolerant.
Didn't they start 30 milligrams the first 3 days?
They did for the first 3 days, and then again the suggestion was that by kicking it up on the day of surgery to 60, that it was inappropriate and created a lethal dose in this patient at that time. And so the question is, they came in and said, no, 60 is fine. You can do that from day one. Our expert says, no, that's not fine. You need to go low and slow, and the fact that you kicked him up to 60 there is what killed him. That was the issue before the jury. And so what do we have? We have the jury hearing from their expert, well, FDA says I'm right. Our expert doesn't get to say that. And so the jury chose the expert that said the FDA supports my position. The trial court recognized the critical issue in this case. That was clearly improper. Trial counsel recognized it's improper. Trial judge said I messed up on the objection. I've got this question from the jury about the FDA in closing. All these circumstances say I need to I need to grant the motion for new trial on this basis. He did not abuse his discretion in that manner. The question again about this, we're hearing about, you need to look at the testimony that we're talking about. The 60 milligrams creating the opioid tolerance is not what this case is about. It's about our theory of the case, saying that this happened too quickly and having them dispute that. They had all day long, and they told the jury from the moment this trial started, they're going to have a different position about that prescription than we do. And then to allow them to come in and bolster that testimony through their expert, the trial court recognized it was inappropriate and did not abuse its discretion in
Ms.
granting the
Stein
trial.
seems to be arguing today, and I don't mean to put words in her mouth, well, that's all I seem to be doing this morning with everybody, but is that your side had presented evidence that suggested to the jury that 60 milligram dosage was approved, safe, okay under the FDA standards. Do you disagree?
Yes, I disagree with that.
Did she
and I
say,
think-
is that what, did I interpret her position right, or did I misinterpret?
I think, yes. She mentioned, I believe, and testified that 3 different witnesses testified about this. Her witness, Dr. SARANITA, did. The
Right.
doctor, it was the critical thing. Our
That's
witnesses
the
didn't.
defendant, so
We would expect her to
doctor's
do
not
that.
going to come up there and say, boy, I
Yeah, of
overprescribed.
course. That was their position. 60 milligrams was safe when that prescription was written on May 21st.
But she also says that, okay, Dr. Serenita comes in and says, FDA says that's good to go, 60 milligrams. Nobody objects to it. Why
Your Honor, but
does it later on, days later in the trial, when her expert says that becomes
Because
upsets the apple cart here?
Again, that should have been objected to, but the reality is that when you talk about cases, and we cite extensive case law talking about all these cases being battle of the experts, and the credibility of experts who were supposedly neutrals in essence, and looking at this case objectively, you cannot suggest the trial court abuse its discretion when an expert, the key expert, is allowed to bolster in the situation. Dr. Serenita did testify that. The other witnesses from our side did not. They testified about the 60 milligrams for a week being what is required to get opioid tolerant, but it doesn't go to the critical question about how do you get to the 60 milligrams, and Dr. Bird's testimony about that. Again, Your Honors, the fundamental error that we've talked about, we cited the cases for that. This deprives us of a fair trial. The critical distinction, again, needs to be not that the FDA was mentioned, not that the 60 milligrams creating opioid tolerance was mentioned, but whether or not their expert on the critical issue in the case, when it was objected to, was allowed to bolster his testimony. The extensive case law says that is flatly improper. This is a battle of the experts. Reversal is required. I would suggest that if the court had denied the motion for new trial, and we were the appellant in this case, you would have to reverse that decision based on the case law and based on what happened below. But that's not what happened. The court granted the motion for new trial, and as we've all recognized, that as an extremely broad and deferential standard in this case, it cannot be said that under the facts of this case, and given that this was the critical issue, and given that the court recognized and explains in his order, I should have done something different with that objection. This shouldn't have come in. And opposing counsel at below saying, whoa, 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 you can't keep doing this. These are our rules. This is improper. Under all these circumstances, affirmance is required. I'm going to defer to our briefs on the tipsy coachman arguments for this morning. If there are any other questions, I'll be happy to entertain them. Otherwise, I'll sit down. Thank you very much.
May it please the court, if, just to clarify, if the fundamental error standard was applicable, there'd be a lot less discretion. I mean, that's when the discretion is drawn in and it becomes more of, and I think we addressed this in the reply brief, it becomes more of a de novo standard of whether the record supports fundamental error. But again, I think fundamental error can't follow if there's no error to begin with the comment. Plaintiff now agrees that, or they admit that maybe Dr. Serenita's direct examination should have been objected to. First of all, I completely disagree with that. The reason it wasn't objected to is because it was what had already come in 3 different times, and all she was doing was tying in what it means to be tolerant to take 60 milligrams a day. Obviously, the FDA isn't going to give a standard of 60 milligrams if it's dangerous and is going to kill someone. So I think that's just, all she did was fill in the obvious. Plaintiff now agrees that they should have, or says they should have objected. Well, what they're really saying is all of this came in without objection, and so what Dr. Rauch said was no big deal. I just also want to just get back to this critical issue in the case. That's what plaintiff says now, that's what they've said in the brief. It's not a critical issue in the case. All one has to do is look at the complaint, or Dr. Lander's testimony, or closing argument to see it is not a critical issue in the case as to what the FDA considers to be the tolerance standard.
What's the critical issue in the case?
The critical issue in the case is whether the long-acting opioids should have been given to someone who had sleep apnea and was obese. That was the critical issue in the case. That is the majority of Dr. Lander's testimony. Now, plaintiff had a lot of criticisms about Dr. SARANITA, but there was...
So, counsel, to kind of just say it in a different way, would you say that the case was about not whether 60 milligrams was safe, but whether 60 milligrams was safe for this patient?
That is it's a much better way of saying it. What I'd like to do is clarify what Your Honor just said, because yes, but what they were really saying was that they were saying 60 milligrams is safe, yes, for a normal patient, and you wouldn't give a long-acting opioid to this patient anyway. It was really about long-acting versus short-acting, but I'm going to have to agree to some extent with that. There was, with how Your Honor just phrased it, there's never any testimony that 60 milligrams is a dangerous dose. You'd never give it to someone. It's a dangerous dose for this patient, and you need to titrate for a patient like that. All of these things are very important because it just contradicts everything plaintiff is saying.
But then the objected to the preserved issue question and answer was FDA says 60 milligrams is safe. And so wouldn't that lead a jury to say, well, it's safe for everybody? Right?
Absolutely not. Plaintiff's counsel, in closing, agreed that everybody knows, that was his words, that the FDA says that's the dosage you'd give. That the issue was whether you give it to this patient. So in fact, he was just talking hypothetically, just like every other witness was, that the FDA has a standard of what they consider safe, which had already come in without objection. It was not a critical issue in the case, and it was one comment which the jury had already heard. We would ask that Dr. SARANITA not have to endure a second trial over one comment that the jury heard on an issue that was not critical to the case. We would ask respectfully that the court reverse the order granting a new trial. Thank you.
Thank you. Thank you, counsel.